right now I can not go into detail about everything here, but only just show you a little bit about this environmental impact report. So the most important of this reporting form. So let's have a look at the content of an environmental impact report, Umweltverträglichkeitsstudie, 环境影响报告书. So there must be included into such a report first an overview of the construction project, a status quo of the surrounding environment of the construction process, then once more these three important terms of analysis, forecast and assessment of this project, and fourth, measures taken by the construction project for environmental protection as well as technical and economic demonstrations, and so on. You can read this if you want, I can send you the PPT and then read about it more. Okay, so the next slide, yes, is something that has to do with some things, some political legal aspect I would like to show you right now, because this law clearly bears the signature of Hu Jintao, the current president of China, of the PRC. And this president has two concepts mainly associated with him. The first is harmonious society, 和谐社会, and the second one is scientific development concept, 科学发展观. And both concepts we can also find in this law actually, because in Article 1, which reads, this law is enacted to promote the harmonious development of the economy, society and environment. So once before, when Jiang Zemin ruled China, he mainly focused only on the economy, and then Hu Jintao went into power, and his new focus was more on a balanced approach between the economy, the environment, and also especially the society. So here we can find a political legal aspect, which is also true with the scientific development concept. Here we can find a stipulation in Article 6 of this law that reads, the state encourages and supports scientific research into the methods of environmental impact assessment and raises the scientific nature of environmental impact assessment. So this is very, very striking, and here we can also find a concrete example of the scientific development concept. Okay. So yes, what I also want to tell you that the background of this second concept, you might ask why exists such a concept, of course. And the reason is that science right now in China is seen as a part of a legitimacy basis for the CCP, because the party tries to prove that their actions are scientific. So this is just something like a new legitimacy basis. Okay, right now I want to talk about the Treble Simultaneity-Principle, 三同时的原则. This is a very, very important principle in legal enforcement with respect to environmental law, and this means that the first must be a simultaneity of design, 设计 of a certain facility or a construction project, and at the same time a pollution and prevention control of this project. The second phase is the second period is the construction phase. So 施工, there must be a simultaneity of a construction of a certain facility and pollution prevention and control. The third is the simultaneity of operation, so when the construction is already done, of a certain facility and pollution prevention and control. So each phase needs an approval by the environmental agency before starting the next phase. So one step after another. Okay, so the second part right now is about repression. So repression regime, the cure and liability regime. And first let's talk about mediation. Just to give you an example, just to give you a definition, I've chosen a definition made by Knut Benjamin Pissler. He had been here in Würzburg in December of last year, and he has also written a an expert report for the German Ministry of Justice to create a German mediation law. And he has, in this expert report, written about mediation in China, of course, because he's a sino-legal expert. And he gives a definition in his paper here: a process during which two or more parties voluntarily arrive at an agreement about rights and duties that are disputable between them, and which is made, the agreement is made under the guidance of a third party and under the adherence of certain rules. So, just to start with the definition, right now let's have a look at comparative law. Rechtsvergleich, 法律比较. So we in Germany generally know mediation from the field of labor law, Arbeitsrecht, 劳动法. While we in China have a general tendency to mediation in all fields of law. So Rechtsgebiet, 法律领域. This has simply to do with the legal culture background, because in Germany we have what is called a culture of disputation, Streitkultur, and we first generally tend to go to court, and in China we have more or less a culture of harmony, as I just told you, and in China the tendency to go to mediation first is bigger than in the West. So this has to do with this legal cultural background. And just to show you the importance of mediation in the PRC, I would like to quote Ding Xiaochun. She is a law professor in Nankai University in Tianjin and also was here in Würzburg around one month. And she said during one of her lectures that mediation is something like judiciary with Chinese characteristics. Or Häuser, for instance, says that mediation is an extreme successful method of dispute resolution. So you see that mediation in today's China is very important, and Häuser also quotes, also states some facts. So, for instance, 90% of all disputes resulting from economic or labor treaties and 80% of all non-economic disputes are solved through mediation. So you see that mediation is very important, but nevertheless there is also a tendency to a more procedural dispute resolution. Because there was a major change in the civil procedure law in 1991, and this change strengthens the procedural dispute resolution. So, for instance, Häuser, to quote Häuser once more, he says that, citation, the development shows nevertheless that the civil process has a more and more important function. And then let's have a look at comparative law once more. This is also what you can find often in the literature, that here the West can learn from China with respect to mediation. And yes, and so for instance, the example that I just stated, the example of this legal comparative survey report, rechtsvergleichendes Gutachten about mediation in China, is such a concrete example. And my own theory, I think you can also find it somewhere in the literature, but I have not found it, unfortunately. So, is that there is some kind of legal harmonization, Harmonisierung, Rechtsangleichung, what we right now know from the European Union. So, 和谐化 between the West and East, and that this we can also find not only in the European Union, but also between China and Germany, for instance. So, this I will leave out. And right now I would like to talk not in detail about the sources of law for mediation, just to show you